essentially saying you can't hold them responsible for the actions of their abusers when they're the victim. And Illinois passed a state statute called the Safe Home Act, which protects now residents of private housing. I mention this just to let you know how compelling some of these cases are. And again, these are really representative cases. I have to say, every week I get clients who come in presenting cases that are incredibly compelling to me. There's a lot at stake, very interesting set of facts, and they also demand legal strategies and legal theories that I've never used before. So I want to let you know how compelling these cases are going to be. I want to let you know how interesting these cases are. You really should get involved in this work. I will now stop talking about subsidized housing, which is really a very interesting topic. And I'll just talk generally about the eviction process, which is what Hank asked me here to talk about. The main thing to know, yes?
Quick question. Somebody's living in subsidized housing.
Yeah.
You know, it's not government, it's like Section 8. They file suit against a landlord and win. Who gets the money? Do they get the money, or do they have to split it with the housing provider?
No, they would get the money. I mean, it would be depending on the claim, but I can't imagine a claim where they wouldn't receive the money.
Okay, thank you.
Sure. And the Section 8 program is government funded. There are some local housing subsidy programs. I don't see too many clients who receive those subsidies, but they're certainly out there. The main thing to know about the eviction process in Illinois is that it's governed by the Forcible Entry and Detainer Act, which is Article 9 of the Code of Civil Procedure. And that governs the process for evicting tenants and obtaining judgments against them for unpaid rent. There are several other very important applicable laws which David and Paul have already mentioned. They're set forth in the material, so I'm not going to go over them right now. Of course, as far as local laws are concerned, the most important one is the Chicago Residential Landlord and Tenant Ordinance, which you've heard discussed quite a bit. And I don't want to repeat what Paul and David have already said about it. Obviously, the RLTO governs most dwelling units in Chicago. And if it does govern the dwelling unit, then the tenants have many additional rights and protections. If the RLTO does not govern the dwelling unit, the tenant still has many protections under federal and state law. And just to use one example, David was mentioning lockouts. And lockout cases are great cases for you guys to get involved in. There are a ton of lockouts all the time. I had one last year in which the landlord locked out my client, not by changing the locks, not by turning off utility service. Those are the most common situations. My client was actually renting a single-family home, two-story home. She was a Section 8 voucher holder. And the landlord, while she was at work, she was a nurse, and while her children were at school, came in and removed all the windows on the second story. And so when she came home, and it was a driving snowstorm, it was actually snowing inside her unit. And that constitutes a lockout, because obviously the landlord's intention is to dispossess the tenant, force them to move out. Now, if the dwelling unit in a lockout case is governed by the RLTO, great, because that entitles the tenant to certain damages equal to 2 months' rent or twice the actual damages, whichever is greater, and it allows for attorney's fees. But if the RLTO does not govern the dwelling unit, the tenant is still protected because the Forcible Entry and Detainer Act itself prohibits lockouts. Okay? So lockouts are never, never, never permitted. A landlord cannot exercise self-help. Right? The only way that a landlord can get a tenant out is by following the proper legal procedure. And in most cases, that will be first serving a termination notice, and then after the termination notice expires, filing a forcible action, going to court, winning the forcible action, obtaining a judgment, and then paying the sheriff of Cook County to enforce the judgment by actually evicting the tenant. Although now the procedure has changed. It used to be that the sheriff would actually physically remove the tenant and the belongings. Now the process, and I've got to say I'm a little confused about how it works, is that they come and they just change the locks. But only the sheriff can do that. The landlord cannot do that. So I encourage you all to get involved in these cases. And again, if the RLTO applies, you could make yourself some money. It's not anything I or my colleagues ever are able to do because we're prohibited from getting attorney's fees, but everybody else can do it. One thing you should know about the RLTO is sometimes there's a conflict between an RLTO provision and state law. If there is a conflict, in almost all cases, the RLTO supersedes state law, and there's a case on that which is set forth in the material. Now, prior to filing the eviction action, this is what the landlord, in almost all cases, has to do. The landlord has to first serve written notice of its intent to terminate the tenancy. There are two exceptions to this rule. Most of them don't apply here in Chicago. One exception occurs when there's a written lease agreement and it ends on a certain date. Okay? In most of Illinois, if the tenant does not move out on the date that the lease agreement ends, the following day the landlord can just go to court and file a forcible action. However, if the RLTO applies, that is not the case, all right? Because the RLTO provides that the landlord has to first provide 30 days advance written notice of his decision not to renew the lease agreement. There are some lease agreements that state that a landlord does not have to serve a termination notice. And in most parts of Illinois, that lease provision would be enforceable. If the RLTO applies, it is not enforceable, okay? The RLTO provides that a landlord cannot waive his duty to provide the tenant with advance written notice of his decision to terminate the lease. So, next question is, what kind of notice does the landlord have to serve? The most common type of notice is the notice served when the landlord wants to evict for non-payment of rent. And in that case, the landlord would serve a 5-day notice. Okay? And the notice has to say, this is the amount of rent you owe. You have 5 days to pay it to me. In other words, you have 5 days to cure your violation. If you don't pay within the 5 days, I'm going to consider your lease terminated, and then I can go to court and evict you. The termination notice does not have to state the date on which the lease agreement will terminate. It just has to say it'll terminate in no less than 5 days. So it can say, it can give the tenant 30 days if he wants to. It can give him 10 days. But he has to say, you have to pay me within this many days, but he doesn't have to say, or he doesn't have to identify the actual date on which the lease agreement will end. I want to point out one thing about subsidized housing again. There is one exception. CHA residents, public housing residents, are actually entitled to 14 days advance written notice of the landlord's decision to terminate the lease agreement. And I think that I have a footnote about this. It's footnote number 2. And there's something at the end of that footnote that should just be deleted. It says see section 10A2 below. That shouldn't actually be there. That's there only because I cut and pasted it from the bench book. But I wrote the bench book, so I can cut and paste my own material. I can plagiarize myself. If the landlord wants to terminate the tenancy because the tenant has violated some other lease provision, aside from the provision that requires him to pay rent in a timely manner, the landlord has to give the tenant at least 10 days advance written notice of his decision to terminate the lease agreement. For instance, if the landlord wants to evict the tenant because she just got beaten up, well, that would be a 10-day notice. Wouldn't be a good 10-day notice in my opinion, but it would be a 10-day notice. And the 10-day notice, as I said, it has to set forth the alleged lease violation with enough specificity to enable the tenant to prepare a defense.